Lawyers practicing in the Middle East or advising businesses working with Middle Eastern partners always feel like walking through a minefield. Consider this example. On January this year, the US President issued an executive order authorizing the imposition of new sanctions against, quote, any individuals owning, operating, trading with, or assisting sectors of the Iranian economy, including construction, mining, manufacturing, or the textile sector, end quote. This included providing significant goods or services used in connection with these sectors of the Iranian economy. According to Steven Mnuchin, the US Treasury Secretary, these sanctions were imposed in parallel with the maximum pressure campaign in place since US withdrawal from the Iran nuclear deal in May 2018. In fact, after issuance of this order, there are barely any sectors of the Iranian economy outside of the ambit of US primary or secondary sanctions. The question raised by this order for lawyers and legal consultants and corporations compliance and regulatory officers is whether providing legal services to Iranian companies and entities engaging with the aforementioned activities can be sanctionable under this order, read together with the previous guidelines. This question has been specifically addressed in a guidance issued by the Treasury's Office of Foreign Assets Control, or OFAC, which goes back to January 12, 2017. In that document, OFAC laid out the circumstances under which U.S. compliance officers, consultants, and attorneys can advise their clients, employees, or others on whether a transaction is prohibited under U.S. sanctions laws. According to these guidelines, providing services is only permitted to covered persons under certain conditions, which is defined in those guidelines. The problem is that previously in 2012, the Iranian Transaction and Sanctions Regulation, ITSR Section 560-553 CFR, had defined categories of general specific licenses on permitting payment for Iranian-related legal services. In a recent blog, we have elaborated on these issues and raised two specific questions that have proven somewhat puzzling to lawyers and their clients in this area. Number one, what is the relationship between the 2017 OFAC guidelines and the 2012 regulations? Does the former partially override the latter? How do they relate to the executive order issued by President Trump in January 2020? Number two, whether lawyers can approve certain transactions with Iranian entities from a legal standpoint. How can one draw a line between providing information on the one hand and giving a legal opinion on the legality of prohibited or potentially prohibited transactions without crossing the red line of facilitating those transactions? If you're a business working in the Middle East and have been facing with these challenges, please read our blog first and then share your thoughts and experiences on existing confusions and problems. If you're a lawyer working on these problematic issues, we also invite you to share your practical knowledge on our platform.